Hello, my name is Dinesh Subramaniam and my student number is 230900134. In this question, Phoebe appears to be an employee since she has a fixed working hour and is considered to be a full-time employee. Based on Section 230 Employment Rights Act 1996, an employee is an individual who has entered into or works under a contract of employment. Assuming Phoebe has such a contract with HCPM, she is entitled for certain rights and protections under the Employment Rights Act 1996. In Phoebe's case, there are several key employment issues under UK laws that needs to be addressed. These issues primarily relate to maternity rights, flexible working requests, and potential maternity and sex discrimination. In my presentation today, I will break down the key employment issues involved. In the UK, one of the primary maternity rights is maternity leave, which is provided under the Employment Rights Act 1996 and the Maternity and Parental Leave Regulations 1999. Maternity leave is available to all women employees, regardless of how long they've been employed. The maternity have entitlements in UK could last for 52 weeks long. The first 26 weeks is for ordinary maternity leave. The next 26 weeks are for additional maternity leave. To qualify for maternity leave, the employer must notify their employer of their pregnancy and their expected due date, usually at least 15 weeks before the due date. Phoebe seems to have been granted with an appropriate duration of maternity leave. Under Section 71 of the Equality Act 2010, Phoebe has the right to return to her previous role after maternity leave unless there is a genuine redundancy situation or other exceptional circumstances. As Phoebe has worked at HCPM for 7 years and her maternity leave began on 18th of October 2024, she is entitled to return to her job when her maternity leave ends. Importantly, under Regulation 18 of the Maternity and Parental Leave Regulations 1999, Phoebe is entitled to return to her original job or, if that it is not possible, to an equivalent role with the same terms and conditions. In this case, her employer has not disputed her right to return to work but has refused her request for part-time work. Phoebe's request to reduce her working hours to 3 days per week falls under the framework of flexible working requests, which employees have the right to make under Section 80 sub F of the Employment Rights Act 1996. This request includes changes to their hours of work, times of work, or place of work. This right applies to all employees provided they have been employed for at least 26 weeks continuously with their employer at the time of the request. In Phoebe's case, she meets this requirement as she has been employed at HCPM for 7 years. The employer is required to consider flexible working requests in a reasonable manner and to provide a valid business reason for refusing the request. Employers are permitted to reject the request on one of the following grounds, which are burden of additional costs, or detrimental effect on ability to meet customer demand, or inability to organize work among existing staff, or inability to recruit additional staff, or detrimental impact on quality and performance, or lack of work when employee proposes to work, or planned structural changes. In this case, HCPM's stated reason for refusing Phoebe's request is that full-time work is necessary for providing a professional and comprehensive service to their clients. Thus, this may seem to fall under the refusal grounds of detrimental effect on ability to meet customer demand. This could be a valid reason, but it still must be examined carefully to determine whether by Phoebe working part-time, it will really have a detrimental effect on meeting the demands of customer. Adding on to that, the Section 80G Employment Rights Act 1996 requires the employer to follow a specific process when rejecting a request for flexible working, including considering the request, holding a meeting to discuss it, and providing a clear written explanation of the decision. The question is silent on this matter. If these procedural steps were not followed, or if the refusal was not based on an appropriate justification, Phoebe may have a claim for failure to properly consider her flexible working request. Under the Equality Act 2010, discrimination on the grounds of maternity leave is explicitly prohibited. If Phoebe believes that the refusal of a request to work part-time is because she is returning from maternity leave, this may amount to maternity discrimination. In Webb against Ammo Air Cargo, the Court of Justice of the European Union held that a woman on maternity leave is entitled to the same benefits as she would have received had she been at work, and should not suffer detriment for exercising her maternity rights. Moreover, refusal of part-time work as a mother could be indirectly discriminatory under Section 19 of the Equality Act 2010, since the refusal disproportionately affects women who are more likely to be primary carers of children. In Southeast Essex Primary Care Trust, the court found that a failure to accommodate a mother's request for part-time work could amount to indirect sex discrimination. It is disproportionately affects women and cannot be justified by a legitimate business reason. Phoebe's request to reduce hours to 3 days a week is based on her childcare responsibilities, which is a protected characteristic under Section 19 Sub 1 of the Equality Act 2010, as it is indirectly related to sex and maternity discrimination. The refusal of part-time work could be viewed as indirect discrimination unless HCPM can demonstrate a legitimate reason based on the grounds of refusal mentioned before. Phoebe's situation involves several potential legal claims and remedies under UK employment law, primarily focusing on the refusal of flexible working requests, maternity discrimination, and sex discrimination. The present candidate would elaborate on the overview of the possible claims she could bring, as well as the remedies available if she is successful in bringing a claim on those three grounds. If the refusal of flexible working request is based on a vague reason, such as the employer's mere assertion that all property managers must work full-time, the potential remedies Phoebe can seek for under the law is reconsideration of the request. Phoebe could request that the employer reconsider her flexible working request, especially if the employer did not follow the correct procedure or the refusal was not based on reasonable grounds. Secondly, compensation if Phoebe feels that the employer's action caused her financial or personal hardship due to childcare issues or inability to return to work in a manageable capacity, she may be entitled to compensation for any loss suffered, especially since it was clearly stated that she could not afford the nursery services for her child. If Phoebe successfully argues that her request to work part-time after maternity leave was refused because she is a mother returning from maternity leave, and that refusal constitutes maternity and sex discrimination, she may be entitled to compensation for injury to feelings. The compensation could be based on the seriousness of the discrimination in line with the guidelines set out in Vento against Chief Constable of West Yorkshire Police. Phoebe may be entitled to back pay or compensation for any financial losses incurred as a result of being denied the opportunity to work part-time. Since in Phoebe's case, the requirement to work full-time could be seen as an unjustified and disproportionate burden on women who are more likely to have child care responsibilities. Thus, if Phoebe can provide indirect sex discrimination, she may be entitled to reinstatement of flexible working. Phoebe could potentially seek an order that her request for flexible working be granted, subject to reasonable business considerations. If Phoebe feels that the refusal to allow flexible working combined with her treatment during the appeal process has created an intolerable work environment, and she is effectively forced to resign, she could potentially bring a claim for constructive dismissal. This occurs when an employee resigns because of their employer's breach of contract. To succeed in a constructive dismissal claim, Phoebe would need to demonstrate a few elements. First is fundamental breach of contract by the employer, which in this case is refusing her flexible working request without valid reason or process. Then she resigns in response to the breach without any delay, and that she takes reasonable steps to address the issue internally, such as lodging a grievance. Given the circumstances, the set steps Phoebe should be taking to reach a successful claim or remedy is to first request a grievance meeting with her employer or to address the refusal of her flexible working request. She should document any communications regarding her request and refusal to ensure she has proof. Then, Phoebe should also consider seeking legal advice to assess the viability of an employment tribunal claim, particularly for maternity discrimination or sex discrimination. And other solution is for her to consider alternative dispute resolution such as mediation. Especially if she wishes to preserve her employment relationship with HCPM, Phoebe could also request that HCPM reconsider her flexible working request in light of the legal rights available to her under employment law. If the refusal is based on discriminatory grounds, she may have a strong claim for compensation. Phoebe has several legal avenues to explore, including claims for failure to consider a flexible working request properly, maternity discrimination, sex discrimination, and potentially constructive dismissal. The potential remedies include compensation for injury to feelings, lost earnings, and the possibility of reinstating her flexible working arrangement. It is important for Phoebe to pursue these claims in a timely manner to safeguard her legal rights. That is all from me. Thank you.